Hi, this is City Attorney John Russo for Oakland, California, and this is another report that we're doing regularly on important cases that our office is involved with for the public to know what it is that we do and what those issues are that are impacting the city in the courts and in the various legal systems. And to help you understand, it's important that we show you some really compelling visual information.
My view is also that nobody is above the law, and if there are clear instances of wrongdoing, that people should be prosecuted just like any ordinary citizen.
Police, politicians, top county and state officials, even judges, all accused of illegally getting paid to play. The FBI says corruption is on the rise as the economy worsens.
The more resources we throw towards the problem, I think the more corruption we're finding.
Nearly 1,200 federal, state, and local government officials have been arrested for corruption in the last 2 years alone.
Starting today, every agency and department should know that this administration stands on the side not of those who seek to withhold information, but those who seek to make it known.
This is a commitment to true transparency, not only in the reforms, but in how we get to those reforms.
Oakland City Attorney John Russo, the quintessential mayoral wannabe, has committed political suicide and can never win an elected position with the revelation of undeniable evidence of criminal wrongdoing, as protests and demands for a resignation and payment of damages are insurmountable and gaining meteoric momentum. In documents filed in Alameda County Superior Court and the state of California in the al-Hakim versus CSAA and the underlying rescue Rutter case, there is now irrefutable evidence that specious Oakland City Attorney John Russo and the City Attorney's Office has been charged with and committed extrinsic fraud, fraud upon the state, subornation and solicitation of perjurious testimony, providing litigation case files and evidence to defendants, spoliation of evidence, fabricating evidence and planning fabricated evidence in the litigation case files, attempting to deceive the public in support of the defendant's litigation theory, calumny deceit, has committed patterned, willful, criminal, fraudulent, and corrupt deception, fraudulent concealment, committed willful, criminal, and corrupt perjury, perjury by omission, made knowingly false statements, collusion, conspiracy to commit fraud, conspiracy, corruption, corrupt misconduct, prejudicial misconduct, obstruction of justice, bad faith, denial of due process, abuse of discretion, gross negligence, bias, prejudice, incompetence, and a conflict of interest.
I believe that the 5 administrative reforms the city attorney and I are offering here today get to the heart of creating transparent, principled, and accountable government in Oakland.
Also, I endorse wholeheartedly the entire package of reforms that's being proposed by the city attorney and the city auditor. I want to thank both of them for their leadership and hard work in coming up with a clear and thorough set of rules and guidelines that are going to help create a culture of strong ethics, transparency, and accountability in our city government.
If Oakland City Attorney John Russo and City Auditor Courtney Ruby truly believe that city employees should be held to the highest ethical standards, that there is a formidable crisis of lack of public confidence in Oakland City government, that people are fatally mad about the unethical behavior and abuse of power in the city government, that it is truly time for Oakland, in quoting Russo, to get on with it to clean up corruption, that Russo and Ruby truly want to enact and enforce their own self-authored whistleblower program, and they are sincere and want the public to believe that city government is operating on the level, then they should start with this complaint to investigate themselves and provide answers as to why Russo, attorneys Mark Morodomi, Randy Hall, Janie Wong, Anita Hong, Sophia Lee, Demetrius Shelton, and Michelle Abney provided the case file to defendants Stephan Barber and Ron Crooks for nearly a year and failed to notify the court of this unpardonable illegal breach in a chain of custody of the file. All of the above have failed and refused to provide the information sought by al-Hakim, and further, all have failed and refused to appear under court-ordered subpoena for deposition testimony twice and under court-ordered subpoena for trial testimony at least once, and have caused al-Hakim and his family to be forced from their $1 million-plus home, office, and over a $20 million lawsuit and multi-million-dollar business for 12 years through the city attorney's violation of the business and professional codes, extrinsic fraud, subornation of perjured testimony, while committing these acts under the color of law with unclean hands, and should be prosecuted to the full extent of the law. The August 1999 city note clearly demonstrates that someone had made contact with Pat Smith before that date in order for her to engage in illegal activities with the city attorney's office. Who contacted Smith? When? How? Why? She admitted during her testimony at trial in the rescue case that she was being paid for her efforts by the defendants. How much was she paid? And what was the basis for her employment? When did Pat Smith review the city file after her employment ended in 1994 and October 1999? Since there's proof from invoices that defendant Ron Crooks had hired John Ratto of DL Glaze, later called ASU, as an alleged adjuster in this case, and we have found out that they had contacted the Oakland Police Department and the Oakland City Attorney's Office and the Department of Insurance in an investigation of al-Hakim under the guise of adjusting and settling the claim in early 1999. It is entirely reasonable to expect that defendants CSAA, Cook, and defense counsels Barber themselves may have initiated the contact directly with Smith and the City Attorney's Office prior to August 1999, or at the very least, it was another of their employees or contractors, such as Doug Kroll, Eller Torres, Lynn Kohler, Mike DeCesar, Gary Halpin. The blatant illegal activities of defense counsel Steve Barber and Sean O'Halloran are well established in this and the underlying case. This file, further, notes clearly refutes all the testimony, alleged evidence, and contentions in January and May 2000 on behalf of Cook and CSAA of their canceling the policy, denying the claim, and demanding repayment for the partial tender of the repairs that they discovered during the October 1999 EUO that al-Hakim had withheld evidence of the city file and misled them in the magnitude of the backup. This also refutes any allegation of al-Hakim not complying with the terms of the insurance contract by not agreeing to CSAA's subpoena of the Crawford files in July 2000 because, as al-Hakim had asserted, CSAA already had them in 1997. And at least a year earlier, in August 1999, in the CSAA files that they had possession of. Not only did al-Hakim provide CSAA with his files from the city in 1997, but clearly CSAA had contacted both Pat Smith and the city's attorney's office before August 1999, had accessed the city file on or before August 1999, planted the evidence they wanted and purged the evidence they knew was damaging before the EUO began in October of 1999, rescinded the contract and denied coverage in May 2000, allegedly on information they discovered during the EUO, then returned the file to the city in July of 2000. It is without any question that the defendants CSAA and Con Crook had this defense strategy long before the EUO began the investigation of al-Hakim in July 1999, contacted both Pat Smith and the city's attorney's office before August 1999, planted the alleged evidence before the EUO, conducted the EUO with the spoliated files in October and November 1999, illegally rescinded the contract and denied coverage of the claim in January and March of 2000, conducted the appraisal with the spoliated files in April of 2000, suborned perjured testimony in support of their appraisal defense strategy, and engineered the fraudulent appraisal that was overturned because of the fraud committed by Con Crook and CSAA. CSAA and Crook rescission of the contract, denying coverage, and demanding repayment was all the product of extrinsic fraud, planting of fraudulent evidence, spoliation of evidence, and suborned perjured testimony in support of their appraisal defense litigation strategy.
Infidel!
You're probably just a good actor and a damned liar and a con man.
This smacks of an attempt to undermine the trial, and the people's work needs to be done.
I think it would be in the best interest of the state if you resigned, because I don't think that the public can accept this anymore.
We're going to follow the evidence wherever it takes us. We'll follow the law wherever that takes us. No one is above the law.